think a lot of you are teaching IHL not necessarily as standalone courses, but integrated within other courses. So may I turn to you, Professor Clapham, as someone with a lot of experience in teaching IHL in other courses. What are your recommendations, especially for courses on human rights, for instance, or international relations, how you would include IHL?
Well, thank you. It's nice to see you all again. I thought I would tell you three things that I used to do in teaching a bit of IHL within human rights, and which I no longer do because I think they're wrong. So when I first arrived here in Geneva, there was a lot in the press about it being the 50th anniversary of the Universal Declaration of Human Rights. So we're talking 1998. And of course, in those days, you couldn't get on TV, and there was sort of internet didn't really have the same kind of reach. And so my students and I were reading things like the Tribune de Genève, which I don't know if any of you come across anymore, but there was a very nice sort of timeline about the history of human rights. And it started with Jean-Jacques Rousseau, in Geneva, of course, and then there was Henri Dunant, and his moment in Geneva, of course, and then it went through to the Universal Declaration of Human Rights, drafted in Geneva, and the Geneva Conventions in 1948-49, drafted again in Geneva, a very Geneva-focused thing. But I rather like this timeline because I thought for teaching purposes, it showed a sort of continuity and the students could relate to it and so on. And I was going through my papers the other day and I found the original thing. And now I rather think it's wrong to present this as one long continuum of progress in history, and that somehow human rights and IHL are just sort of stages along the way. I think in teaching human rights, I've come to sort of say, actually, no, the history of human rights has its own trajectory. And even if they were drafting the Universal Declaration of Human Rights and they were drafting the Geneva Conventions in the same city in the same year in 1948, those of you who are familiar with this will know Robert Kolb has written a very good piece of research which shows that they didn't actually talk to each other at all. Or if they did, it's the exception. And we're still living, Marco and I live this a lot, all the time, of sort of two different groups, the human rights groups and the IHL types, who, of course, meet from time to time, like today, but the way in which the law develops and the way in which things progress are not necessarily all interconnected and part of some march towards history. So I've sort of stopped that, and then probably I exaggerate a little in the other direction to say these are two completely different routes, and they don't really have the same aim. Just while I'm on the history, I don't know, has anybody told you a bit about this room? Did you have a talk about where we are in Villa-Moignet? So just because it is part of the sort of historical approach to this. This was Gustave Moignet's home, obviously one of the founders of the ICRC. And because I did a little bit of research on this topic, this was his living room, and about where Professor Sassoli is sitting now is the desk where he wrote the first Geneva Convention. So we are, in the presence of history here with Gustave Moignet. Why not? So he, of course, was the drafter of that as the lawyer. Even if Dunant, took a lot more of the credit. But the point is that I don't think you can sort of link all this up as one single route, especially if you're trying to teach the law of human rights and the law of international humanitarian law. So again, there was a temptation, certainly when I first started teaching, reading the textbooks and talking to students, to sort of say, well, of course, the focus on the individual starts through Nuremberg and the prosecution of war crimes, and that's the emergence of the international on the world stage. And then we have the individual as a bearer of human rights, and it's all connected up. And both IHL and human rights are about the dignity of the individual. But again, I've stopped doing that. I think it's misleading. I think it's better to give, as Professor Sassoli suggests, give the students the tools to try to unravel how IHL works. And as you all know, IHL is not really about the protection of the individual most of the time. A lot of it is about other things which are entitling states to target certain military objectives or whatever, but the individual is not the focus of that discussion. So I have moved away from suggesting that these are pulling in the same direction, and I suppose I go more into, when I'm teaching human rights, trying to show that actually there may be a tension here, and of course that's what the students begin to find interesting. So these days it would be impossible to teach a human rights class without talking about drones and targeted killing and counter-terrorism. And at that point, you have to explain how something could be legal under IHL and perhaps illegal under human rights. And to try to show that the fact that something is not prohibited under one branch of law might not necessarily lead to the conclusion that it's legal under the other branch. And as many of you know now, this is an interesting area. It depends whether you think international law is permissive and allows you to do things, or whether it's just a set of prohibitions. But I think that's a more honest way into the topic with students. And we had the discussion yesterday about detention in international and non-international armed conflict. Again, you can't teach human rights law and the Hassan case, for example, which we discussed yesterday, without also giving them an introduction to what international humanitarian law might entitle you to do. So, to be frank, rather than stressing this as one harmonious march towards human progress and the protection of the individual, I tend to focus these days on the tensions. And the fact that there are two worlds. Françoise Hampson has an interesting expression which she's used to say, these days it's important to stress that there are very few people who might be what she calls bilingual. And by that she means able to discuss an international humanitarian law problem with the same authority that they could address a human rights problem. And I think that, I used to teach bilingually at the Institute when all students had to speak English and French and all classes were in both languages. But I think in teaching human rights, I would sort of stress to them that it's not enough to think that international humanitarian law is for times of armed conflict and human rights is for times of armed peace, and I only need to know one and be specialised in the one. Because inevitably, there will be times when they need to know both. I'll finish with an example maybe of why somebody learning human rights might need to know IHL even in times of peace. The obvious example being a question of universal jurisdiction arises either for the prosecution of a war crime in non-international or grave breach in international armed conflict. And you would have to be able to understand that to pursue that individual before national courts, even in Switzerland, which, thanks to Marco and the work of trial, I mean, people do get prosecuted in Switzerland, which of course is a country not in armed conflict, for crimes committed in other countries, war crimes. And therefore trying to teach a student who's interested in these things, and they will inevitably be interested in prosecuting those who have violated international criminal law, you have to give them both pictures. And that has been a bit my approach.
Professor Klappa, if you can elaborate in the relationship with international relations that you were about to talk about, that I think is very interesting.
I'll use the same methodology that I used before to say that I got this wrong when I first started teaching, and I'll tell you what went wrong. I assumed that these international relations students needed to be told what the law was, and that if I talk about, for example, proportionality, it has a meaning. And that's really the only meaning that they should be interested in, because it's a law class for international relations, and if they get it wrong, they're not going to pass. And of course, I've realised now that that is not necessarily the way to go, because there may be their understanding of proportionality within international relations, which is closer to what is actually going on in the world than what I am talking about. And after they leave the classroom, I like your expression that they should take what I've presented to them and relate it back to what they're doing and sort of have an aha moment, but continue with what they need it for. And so I realized that international relations students who were interested in proportionality in the context of an armed conflict, because just war theory teaches them that it's somehow all wrapped up in the jus ad bellum, the civilians and the proportionality and all the rest of it, it's no good me saying, look, that's a separate branch, you're going to do that with Marco Sassoli next week, we're only talking about this kind of proportionality. I had to meet them halfway. I had to say, look, when your colleagues talk about proportionality, when you are reading about it, when you're writing about it, this is what's going on. And when we're talking about it, this is what's going on. And sometimes there will be a mixture. And I sort of adjusted my sort of rigid approach to, as I say, meet them. I'll give you one other example, it's a pretty obvious one for this audience. I've been teaching war, obviously laws of war, but war as a concept to international relations students. And of course I can tell them what war is for an international lawyer, but they are working with these projects out of Sweden which defines war in a completely different way. And if I sort of ignore that and say, well, your definition of war is wrong and mine is right, and I'm going to talk only about my definition, it's useless for them, because when they go on to do their postdoctoral studies in war and conflict and civil war and all the rest of it, they need to know what everybody else is talking about and how that might be legitimate, even if not legally correct in other contexts, and how to be flexible and work with it. So I've adjusted my my approach to them, and I think that's important if you're teaching international relations, because they're not going to be international lawyers when they leave your class. They're going to go back as political scientists or an advisor to a prime minister and so on. And I think, as I tried to say, and I'm glad you picked it up, that if you give them the tools to know that when Sir Michael Wood is talking about war, he means one thing, and when the president of North Korea is talking about it, he might mean something else. And to be able to distinguish what's going on, rather than saying you're right, you're wrong, then you win over your international relations students.